Hello, I'm State Representative Jeanine Nodder. This week on Chatting with Jeanine, we will be discussing an item on the November 6th ballot, CACR 26. But before I introduce my guests, I want to remind everyone that we have just one polling place here in Merrimack, and that will be at the high school. Not JMU's, but the high school. I also wanted to mention that the latest word on the ballot is that the two parties will be separated. When I was on Tony's show a while ago, we were told that the names were all going to be in a big long line and everything was going to be mixed up and you had to hunt and look for your candidates. But Diane Trippett did call Tony Pellegrino and said, don't worry about it, the parties will be separated, so I'm relieved. Please vote on November 6th. I believe that it is crucial that we get a new president. And the only way to retire Obama is to vote for Mitt Romney. I will be happy to vote for Mitt Romney, and I'm also be voting for Frank Ginta for Congress, Ovid Lamontagne for governor, Jim Hardy for sheriff, and the great slate of 8 for Merrimack State Representatives. The slate of 8 includes Dick Berry, Dick Hinch, Jeanine Nodder, that's me, Lynette Peterson, Phil Strait, Kathleen Stroud, and Joe Thomas. I ask for your vote, and I hope to see you at the polls on November 6th at Merrimack High School. Question 1 on the ballot is for no income tax. I will be voting yes on number 1, no income tax. And I hope you will do the same. Whoops, where are we going? We're playing cameras here. I'll introduce my guests now. Okay, so another item on the ballot is CACR 26. I know that sounds like a foreign language, and 2 of my esteemed colleagues are here today to define and explain CACR 26 and hopefully convince you that it is something worth voting for. So Representative Kevin Avard.
Jeanine, how are you?
I'm great, how are you?
I'm well.
And Representative Dan Itse, you've been on the show before, but it's been a while. So welcome, gentlemen.
Thank you.
Now, Dan, I know that you're the chairman of the Constitutional
Review and Statutory Recodification.
Oh, I forgot the statutory. I had recodification. Constitutional Review and Statutory Recodification. I know whenever I have a question on the Constitution, you're the one I go to. And
I sit on the Redress of Grievance Committee.
Right, and that's why I asked you to be on the show today, because when we voted on CACR 26 in the House, I happened to catch out of the corner of my eye. You stood up and was like thanking people all around you. I could see the emotion on your face. This item means a lot to you, and
to the people in New Hampshire.
Right, and before I just want one more thing to say. This summer I went to a meeting at the State House, and there was a man in the elevator. I said, "Oh, where are you going?" And he told me which floor he was going to, redress and grievance. I said, "Oh, Kevin Avard's on that committee," and he had nothing but praise to say about you.
Oh, nice.
And this man had not seen had not been allowed to see his children for a number of years, and he was very grateful to you.
I'm getting calls all the time, people that feel as though the rules of the court have totally abused their due process and their rights. And in the process, good parents have been separated from their children 1, 2, 3 years or more, and having not committed any crimes. And a lot of that is related in some respect to the rulemaking ability of the family court, where rules of evidence are just totally overlooked, and admissible would be something like hearsay, third-party witnesses, and devastates families. And I'm getting calls over and over and over again. Rule 1.2, Rule 3.9, and there's a few more, but I'm not an expert like Dan is on that type of stuff. So, but we're seeing the result of this, and so consequently, we've had a number of forums, and I've actually had Dan come on my show along with Representative Itse and Mursky to talk about this.
Yeah, tell me about your show. It's called Speak Up?
Speak Up NH, yeah.
And I know you tape in Nashua, but it's also available online?
Yes, it is. You can go on YouTube or Google it. Speak Up NH generally comes up, and you'll see some of the people that have actually come before the Redress of Grievance Committee. They'll tell their story. It basically mirrors the committee, but it allows people to tell their story in about a half hour, 45 minutes. So we've actually had Dan come on the show with Representative Mursky and
Ingerson and Sorg.
Ingerson and Sorg.
Good representatives.
And they basically tell the historical context of why we've got to where we're at, and the fixes that need to be implemented. And so there's a history behind this, and I'm just going to turn this over to Dan.
Thank you. And that's one thing that's really important for the people to understand is why they're here. You can't understand why you need to vote yes on question 2 unless you understand why question 2 is there in the first place. What we're amending with question 2 is Article 73A. It's not an article of long standing. It's barely 33, 34 years old. 1978 is when it was adopted. And so it's a relatively short experiment in our government. It was put there for a very valid reason. It came out of the 1974 Constitutional Convention. And at that time, prior to Article 73A, each superior court made its own rules for the county. So each county had different court rules. And the purpose of Article 73A was to consolidate all of that rulemaking power of the courts into the Supreme Court so that all of the counties would have the same rules. And it had as a last sentence, such rules will have the force and effect of, or rules so promulgated will have the force and effect of law. And this was actually of concern in the convention. And I've gone back and read the convention minutes, and there was a discussion at that time as to what this really meant. Did it, and the upshot of it was that the legislature was going to retain all of the power that it presently had to make rules for the practice and procedure in the courts. Nothing was going to change. And it's something that the legislature has handled routinely over the last 200 years, whether it was rules regarding contempt of court or evidence. All those things were, if there was a dispute or a deficiency in the rules, the legislature handled it. There was no intent to take that away from us. However, during the last 34 years, the Supreme Court has routinely pulled more and more of that power into themselves and said that because of Article 73A, the legislature had no power to legislate inside the courts.
All right, I have a question for you, because I know some people, they'll go in to vote and they're like, I don't know what this means. There are some people that don't even know what you mean by Article 73A. What is that?
Article 73A is the amendment that says that well, maybe I should read it.
Yeah, I'm turned to it right here.
I'm gonna have to. Well, why don't you want to read it? Because I'll have to get my glasses out.
I have to put mine on.
We all need glasses.
Well, this is your New Hampshire Constitution. Article 73A is says this: the Supreme Court Administration. The Chief Justice of the Supreme Court shall be the administrator head of all the courts. He shall, with the concurrence of a majority of the Supreme Court justices, make rules governing the administration of all the courts in the state and the practices and procedures to be followed in all such courts. The rules so promulgated shall have the force and effect of law. And Dan, I remember going to your committee, and we had the Bill Gardner in there, and the ballot, that last line wasn't on the ballot.
It was not on the ballot. It was in the convention. The laws of the state did not require the amendment to be on the ballot in those days. That's one of the changes that happened shortly after I came to the legislature in 2001, was to require, precisely because of this controversy, to require the actual amendment to be on the ballot so that people would know precisely what they were voting on.
No, Bill Gardner, you mentioned, he's the Secretary of State.
Correct.
Now what CACR 26 or question 2 does is add a sentence that says that, and I'm going to have to paraphrase here because I don't have it in front of me,
I know.
that the legislature shall have concurrent jurisdiction over the practice and procedures to be followed in the court. And when there is a conflict between court rules and statutes, statute will prevail.
And there are some people that won't know what any of those words are, too.
Okay, statute, laws.
Make it easy.
Make it a layman's and this is a layman's because Dan's wrapped up in this and he's very.
I always learn a new word when I hang out with Dan.
But basically, what I tell people is that the House is their voice. The House is the people's voice, and if the House is involved, that means the people are involved. And if the people are being egreged or have a problem with the rules of the court, you can't go to the judge and say, Your Honor, this is a bad rule. Rule 1 point, waiver of rules. You can't. That's a bad rule, Your Honor. He's going to laugh at you, or she's going to laugh at you. Rule 3.9, where there used to be an automatic appeal. Now there's a discretion of the Supreme Court to say, well, I don't have to, based upon familiar status. That was in 1980 that I believe that came about. So they're making up these rules, and it violates your constitutional rights. We had one bill that came up before us. There was you're allowed to face your accusers, right? There was a House bill. Was that 415? House Bill 415.
House Bill 415. Yes.
And a person can be accused of something, that be put in a sealed envelope and given to a judge, and the judge says, you don't need to know what's in that sealed envelope. In the meantime, I'm going to take your child away from you. Your Honor, I need to face my accuser. No, you don't. I have a sealed envelope, and what's in the sealed envelope, I'm going to say, you can't see your child. But what's in the sealed envelope, that's my business, not yours. That's a layman's approach to this, so that we can go to the House and say, hey, look, I'm really being hurt by this. And the House can pass legislation or work on a piece of legislation to bring before the court or challenge some of the rules. So that's the important. It brings back the people into the play. It makes the courts, though separate, yet accountable to the people. How did I handle that?
Pretty well. It does make the court accountable to the people, and if the people believe that their constitutional rights, their due process is being violated by the way the court rules are constructed, or the court not following their own rules, then they now would have the power to come to the legislature and say, we need this rule changed. And if the legislature agrees, they make a different rule, then that is the one that has standing, provided that doesn't violate other articles of the Constitution. That's the last sentence, which has always been the case. I mean, Part 2, Article 5 says that we're not allowed to pass laws that are contrary to the Constitution. So, that's part and parcel. The important thing is that, for example, you have Rule 1.2 in the family court and probate court that says, in the interest of justice, the judge may waive any rule. Well, we might amend that to say that the judge has to give a written justification for the waiver of the rule, right. Which does two things. One, it forces him to sit down and think, does he really want to do this? He doesn't want to have to do this every day to write it down justification. The other thing is that if the person is aggrieved by that rule change or that lack of enforcement of a rule, they have something by which to appeal to the higher court. They have a written document that that they can reference that says, this is why I was violated by the court, why you need to overturn this decision.
If there's no accountability, then you get built-in tyranny. You have a body of government that becomes unanswerable to anybody. And if that same body is making up its own rules that have the effect of law, then basically you have appointed people making laws and you have no representation in that whole process. All this really is a compromise. There were some of us that wanted to wipe this completely off because this is relatively new, 1978. This isn't what our founders had intended. And it's within that 30-year period, 38 years or however, we've seen all cancers grow with it. There are unintended consequences that came along with this, which means we need to take this document very seriously and not mess with it, because these people were brilliant that made this Constitution. However, now we see some of the effects. So in the process, there's a compromise. The Supreme Court justices, the Senate, and the New Hampshire House came together, and that's how we got CACR 26.
Now let's define CACR. What does that mean?
Constitutional Amendment Concurrent Resolution.
Okay. And what's a concurrent resolution?
Which means that the governor does not sign it. We have in the House, we have House resolutions, House concurrent resolutions, and House joint resolutions. House resolution only involves the House of Representatives. A House concurrent resolution just involves the House and the Senate. And a House joint resolution involves the House, the Senate, and the governor.
So a House concurrent resolution, it does not involve the governor, so it's just us and the Senate.
Correct. So
Okay.
a constitutional amendment recommended by concurrent resolution.
And I think, was
Okay.
it 3/5 vote you need for that?
3/5 in each chamber of the legislature, yes. And then 2/3 vote among the body of the people.
And I hope
Those
the
present
camera's
voting.
picking up the yes on
Yes.
what does it take? Yep, okay, I got a thumbs up from the cameraman.
So in essence, really, all this is doing, and it's giving back the people the power that belongs to them. It was taken away, or it, not even intentionally, it grew away, or it degenerated.
Well, I like the word usurped, but
Usurped, there you go.
I mean, it puts unfortunately a negative flavor on it. But you have to realize in our government, and stated in our Constitution, the government has no power that doesn't first come from the people themselves.
Right.
So the court's power to judge cases is really the people's power to judge cases that they've delegated to the court. And in 1978, they delegated the power to make rules for the court from the superior courts, where they had been made by just practice, to the Supreme Court, never intending to take that power away from the legislature.
Can you give me an example of who this would help? Like we talked about that man who hadn't seen his kids in years.
Well, it'll help just about everybody. It helps all the citizens, number one, because it does make the courts a little bit more accountable. Keep in mind also, when a change has to be made, it's not just going to be like this. Well, the legislature is just going to snap their fingers and they're going to make a change in the courts. There has to go. The rules have to go before a committee. It has to be heard. Then it has to go before the House. Then it has to go before the Senate. And I believe that then
Then it would have to go before the governor as well.
So this is a slow process, but all it is a process. It's a mechanism. It's a tool to give back the people their power. That's the most important thing. And who would it help? Well, if we introduce legislation, just like Dan said, for instance, in the interest of justice, there's a waiver of rules, and then of course there has to be a written decision. We just add that into that rule, so that makes it more fair for the people. Well, Your Honor, you're just waiving all these rules. Why? From what I understand, Rule 1.2 was a very good rule. It was there for people who might have gotten caught in a snowstorm or something and couldn't get to court in time and didn't have their evidence with them. Your Honor, oh, I forgot that piece at home. Oh, we'll waive that rule for now. Bring it back at another time. And somehow that's grown into a cancer where a person could spend $50,000, $60,000 worth of lawyers' fees and on evidence and have that evidence and not even be looked at. And then a guardian ad litem would come in, and whatever that guardian ad litem would say would have precedent over
reality.
And so some of that could be personal. Some of that, the guardian ad litem could be playing golf with the judge. Or the guardian ad litem might be friends with one of the other people instead of representing strictly the child. Or the guardian ad litem might want to make some extra money. Your Honor, I'd like to extend this case. I know it's $1,000. I need another $1,000. And on and on and on. And then the cancer grows, and some of the problems is money and other things. This is a really complicated issue when it comes to the family court issues. So what we're saying is, wait a minute, we have clear and convincing evidence, or we have real evidence before you, and I'm submitting this evidence. Please look at it. Don't just dismiss it. Rule 1.2 says,
well, and even
waiver of rules.
just how they apply rules of evidence. observed the criminal trial of one of my constituents. And on one of the days of the trial, the judge did not allow in evidence because it didn't prove their innocence. Now, remember, you're supposed to, all the defendant is supposed to have to do is cast reasonable doubt that it happened the way the state said. And in this case, for example, the state is, without getting into the particulars of the case, the state's saying that they left after November 30th, and the defendant is saying, I left on November 11th, left the state. And he has rent receipts from before November 30th in Massachusetts. And the judge said, well, you could have been living in Massachusetts and paying rent living in New Hampshire and paying rent in Massachusetts, so I'm not going to allow that evidence in.
So it goes on and on and on. There are many different areas in where we've seen before our committee where due process.
Who is the chairman of Redress and Grievance?
Paul Imbertson.
Okay, yeah, he's good, and you had him on your show. You mentioned earlier.
Yes,
Yep.
yeah, we had Paul, Representative Mirsky, Representative Sorg, and Representative Itse, and they all basically talked about the historical context of how the legislature worked from day one until now, with and without. Well, I mean, there were times where the legislature had wiped out the whole court and started all over again because of corruption.
Really? Wow.
Well,
That's
until 1968, we did not have constitutionally protected courts. All the courts of the state were legislative courts, like the family court, district court, and probate court. Mm-hmm. In 1968, partly because of the instability produced when the legislature would wipe out all the courts. Now, granted, 1968, the legislature hadn't wiped out any courts since 1870.
Dan would know
1873 was the last time we'd wiped out the court, so it wasn't a current event.
Right.
Nevertheless, the people chose to put the existence of the Supreme and Superior Courts beyond the reach of the legislature. One of the advantages was if you had a corrupt court system, instead of having to address or impeach each judge, you could just say, we're no longer going to have a superior court, we're going to have a superior judicial court, change its name, and appoint new judges. So it allows you to make
But corruption
blanket
happens.
change.
It happens,
Mm-hmm.
and whether it's a state rep, a state senator, or a judge, or anywhere in our government, corruption can happen, and it needs some accountability to the people. If there's no accountability, it will grow like a cancer, and it will destroy the people's faith in our court system. This is a restoration of that faith. It is a way that allows everybody to stay honest, and this was a great compromise. And I know that there's articles out there. I don't understand where these people are coming from.
Right, I was going to ask you about that. We have about 3.5 minutes left, but what is the other side saying? I know that there are people talking against this.
I've heard Dave Campbell from Nashua say there's no problem.
Yeah, hear no evil, see no evil, speak no evil, I guess is the...
And that's coming from an attorney. Keep in mind, attorneys, and I'm not an attorney. Are you an attorney?
No.
Are you an attorney?
No.
Okay, so we're safe. So attorneys, and I am being a little funny, they have to play by the rules. Otherwise, they can become despised litigants. And if they ruffle the feathers of the court, well, that will affect all their clients.
All their clients and even their livelihood. They owe their opportunity to practice law to the Supreme Court.
So they got to play by the rules. So even though they represent you, they first represent the courts.
That's an important distinction.
And people don't know that.
He's running for speaker too.
Who is?
Dave Campbell. Yes, he is.
Oh, is he?
Yeah. Well, this Merrimack is toll town, and so and he's not our friend on the toll issue.
Well, I think Speaker O'Brien did a great job by the people by allowing this new committee to be, at least there in a formal setting for the people to be heard. Mm-hmm. That is where government has to, they start worrying because, all right, now we're accountable to the people. There's nothing wrong with that. That's transparency. Everybody's talking transparency. I know out in Rochester, some reps said, hey, we're running on transparency. Well, it just so happened you were put on that committee. And come to find out, we're making everybody aware we're watching you in government. And you're going to be accountable to the people who put us here, at least as long as we have that committee.
Right.
Thank you, Speaker O'Brien.
Yes. Yep. I think he did a great job too, and I'm just always amazed at the stories and the outright lies
Well,
being told
having some
by,
legislative experience, 'cause you were both freshmen.
Yeah.
This was my 6th term in the legislature, and I would have to say that Speaker O'Brien was the most tolerant speaker of any that I have served under when it came to how chairmen vote, debate on the floor. I like to tell people that if any chairman had ever voted against committee reports as often as I did, they would have found their buttons in the gallery, and I was not alone.
Well, gentlemen, we have
That's in past administration, and not in this one.
We only have a half a minute left, so I just want to wrap it up by saying thank you. Thank you for being on the show, and thank you for speaking out for number 2. What is it? CACR. Well, on the ballot, it will say yes. Vote yes on 2, and also please vote yes on 1. No income tax. We don't want it. You want an income tax? I don't want an income tax.
I don't want an income tax.
That's why we live here. Jeez. And again, voting is November 6th at Merrimack High School here in Merrimack, and please vote. Please vote and. Hopefully
and be heard. Control your government.
Yeah, speak up and be heard, and check that out on YouTube if you'd like. Google it. Speak up and be heard. Speak up NH on YouTube.
Thank you for watching.